Hello all, welcome to my new video. Today I am going to discuss about mortgages. What is mortgage and what are the characteristics of different types of mortgages. Mortgage is defined in section 58 of Transfer of Property Act. So before coming to the legal definition, we will just understand the concept of mortgage. For example, if one person needs some money, for example, Mr. X needs 10 lakhs rupees. So he approaches a bank or financial institution for getting the loan for 10 lakhs rupees. So bank verifies his KYC documents and income proofs. After verification, bank finds that okay, he is eligible for the loan of 10 lakhs rupees. But the bank will think that if he defaults the payment, what will be the remedy? How can the bank realize the amount if he defaults? So there should be a security. So the bank will ask him, what is the security? What security you can provide to secure your loan? So he can either provide a movable items or an immovable item like gold or a vehicle. Like movable items will be, it is called as a hypothecation or a pledge. But if he is Mr. X is providing an immovable property, a house or landed property, a building, something like that, that transaction is called mortgage. An immovable property is offered to secure a loan and he obtained the loan. This kind of transaction is called mortgage. So now we will come to the legal definition. Legally it is defined in section 58A of Transfer of Property Act. So a mortgage, as per the legal definition, a mortgage is a transfer of an interest in an specific immovable property to secure a debt. This is the legal definition. So transfer of an interest in property. What is the interest in property? So interest means a right in the property. Right means if he owns a property, we have several rights in the property, like right to sell the property, like to possess the property, right to take the income from the property. This kind of load of rights are there. Altogether these rights creates an ownership in the property. So entire ownership is not transferred. Any one of right, any one right will be transferred. For example, the right to sell is transferred to the creditor for securing his loan, or right to possess is transferred, or right to take income from the property that is transferred. So this kind of any interest is transferred to secure a debt, that is a mortgage. So based on the transfer of interest, there are 6 kind of mortgages. We will go to that. Before that, we will just understand 3 terms used in this mortgage. That is one important thing is mortgager. What is mortgager? Who is mortgager? Mortgager is the person who offers the security or who execute the mortgage deed in favor of the creditor. He is the mortgager. So in favor of whom he is execute? In favor of the creditor. So creditor is the mortgagee. Creditor is the mortgagee and debtor is the mortgager. This we have to understand. And the mortgage money, the loan amount which he got from the creditor is the mortgage money. These are the 3 terms used in mortgages. So now we will discuss about the 6 different kind of mortgages. This is based on the transfer of interest. So what are the 6 mortgages? These are explained in section 58B to section 58G. So first one is simple mortgage, and second one conditional, mortgage by conditional sale, usufructuary mortgage, English mortgage, and fifth one mortgage by deposit of title deed or equitable mortgage, and the last 6th one is anomalous mortgage. These are the type of mortgages. We will come to the details of these mortgages. First one, simple mortgage. In simple mortgage, the mortgager has a personal obligation to pay back the amount. First condition. Second condition is right to sell is transferred to the mortgagee. So mortgagee can sell the property when he defaults the payment. These are the two conditions, requisites for simple mortgage. All these terms has to be mentioned in a mortgage deed, and mortgage deed should be registered. The limitation for this mortgage, for execution, for realization of money or filing a suit is 12 years from the last due date. So these are the requisites for a simple mortgage. Personal obligation is there, and right to sell is also transferred. Property can be sold through court proceedings only. Directly mortgagee cannot sell the property. These are the requisites. And the second one is conditional sale, mortgage by conditional sale. This is actually a sale deed is executed by the mortgager in favor of the mortgagee. Sale deed is executed, but this sale deed is not an absolute sale deed. This is a conditional sale. What are the conditions? First condition is, if the mortgager fails to pay the amount within the particular time frame, then this sale deed becomes absolute. So there is no other sale deed or other process is required to realize the security. So first condition is that if he fails the payment, then this sale deed becomes absolute. The second thing, if he pay back the entire amount, the mortgager pays the entire amount, what happens? This will be void. The sale deed already executed will be void. This can be mentioned in another way also, that if he pays the entire amount within the particular period, the mortgagee has to reconvey the property in favor of the mortgager, the debtor. So this kind of mortgage is called mortgage by conditional sale. Now we will discuss the third one, that is usufructuary mortgage. In usufructuary mortgage, the first point is the mortgager has no personal liability to pay the amount. He transfers the entire property absolutely to the mortgagee, means the creditor. So how can the creditor realize the amount? The creditor can take the income from the property. He can hold the property and take the incomes, maybe rental income or any agricultural product or something will be there. He can sell the products and collect the amount, and he will adjust this income to the loan amount. So he can until he gets the entire loan amount, he can hold the property. There is no right to sell. The creditor cannot sell the property. He can just hold and take the income. So until the full payment is received, he can hold the property. There is no limitation also. So this is the kind, there is no personal liability to the debtor. Debtor need not pay any amount. He cannot ask to the creditor cannot ask the debtor to repay the amount. He can only collect the income from the property. This method is called, this form is called usufructuary mortgage. Now we will discuss the fourth one, that is English mortgage. English mortgage is actually a combination of simple mortgage and conditional sale, mortgage by conditional sale. In this, there is personal liability to the mortgager, debtor. He has to pay the entire amount. The liability is with him, personal liability is with him. He transfers the property. Not in simple mortgage, he doesn't transfer the property, possession of the property to the creditor, but in English mortgage, he transfers the possession of the property to the mortgagee, the creditor. And the third condition is, there will be a condition, a proviso that this property has to be reconveyed when the mortgager pays back the entire amount. So these are the three requisites for English mortgage. Now we will discuss the fifth and most important mortgage, mortgage by deposit of title deed or equitable mortgage, EM. This is most widely used form of mortgage. Most of the banks and financial institutions are used this because it is very convenient to execute and very low cost. A mortgage deed is not at all required. All other forms, the mortgage deed is required and the mortgage deed has to be registered. In this form, registration is not required. Only MOD, Memorandum of Deposit of Title Deed, just to record whatever documents are deposited, that is MOD. So we will check what are the requisites for creating a valid mortgage by deposit of title, equitable mortgage. There are mainly three requisites are there. First one, debt. There should be a debt. Debt means the debt can be an existing debt or a future debt. The second point is deposit of title deeds. Original title documents to be deposited. You cannot create a valid mortgage by deposit of title deed by accepting a photocopies of title deed. Originals are required. This is the second point. And third and most important thing is intention. Intention means intention. The mortgagor should have an intention to create security for his debt. With an intention, he is depositing. So without the intention, if any mere deposition will not create any valid mortgage. Intention, deposition of title deed with an intent to create a security creates a valid mortgage. So if somebody disputes, if the mortgager make a dispute before the court that he deposited the title deeds only for the preparation of some loan documents, then it is the duty of the creditor, duty of the mortgagee to prove that there was a clear intention to create a security for his debt, for which we have to prepare a MOD, Memorandum of Deposit of Title Deed, in which we mention that I have deposited, the mortgagor execute MOD, and he says that in the document he says that he has executed, he has deposited the title deeds with an intention to create security for his loan. That is the only document. So if we produce that, we can prove without doubt that he had an intention. The mortgagor has an intention to create security for his debt. So this is the most important point. And since there is no mortgage deed, we only execute a MOD, Memorandum of Deposit of Title Deed. This document is actually an instrument which records the past transaction, concluded transaction, and there is no other terms and conditions. All other terms and conditions are mentioned in a loan agreement separate regarding the interest, term of loan, termination of loan, everything is mentioned in a loan agreement separate, and MOD is separate. So in this MOD is only recording a past transaction. You should make a note that the date of MOD should be a subsequent date from the date of actual deposition, because if the customer deposit the document today, then the MOD will be executed on the next date, then only it comes a recording of past transaction. If an instrument which records the past transaction, then the registration is not at all required. So this is the rule, and this is all about the mortgage by deposit of title deed. And we will now discuss the last one and the sixth one, anomalous mortgage. Anomalous mortgage is a combination, anomalous mortgage is actually a mortgage which doesn't have a characteristics of the other five, then it is called anomalous mortgage. It can be a mixture of two mortgages also. For example, if we create a mortgage, usufructuary mortgage, in usufructuary mortgage we transfers the possession to the mortgagee, and mortgagee can collect use the income from the property and adjust to the loan amount, and there is no right to sell. Mortgagee cannot sell the property. Mortgagee has no right, creditor has no right to sell the property. He has only the right to take the income from the property. So in that type of mortgage, we just include one additional clause that the mortgagee has also the right to sell the property. Then the character of the instrument changes, character of the mortgage, usufructuary mortgage changes, and it is called anomalous mortgage. So These are the 6 type of mortgages mentioned in section 58 of Transfer of Property Act. Now I will tell you about a popular legal maxim, that is, once a mortgage is always a mortgage. What does it mean? It means once a mortgage is executed, then the mortgagee or mortgager has some rights which is provided by the law itself. For example, mortgager has a right of redemption. That means whenever he pays back the entire amount, he has the right to redeem his property. He can take back the property from the mortgagee, from the creditor. This is his right by law itself. So any covenants, any terms which includes by prohibiting this right is invalid. Once a mortgage is executed, then such covenants is invalid. That is what says this maxim says. Once a mortgage is always a mortgage. So I think you have understood all these points regarding the mortgages which is mentioned in section 58 of Transfer of Property Act. I think everything is clear. So thank you for watching.